Hello, I'm Stephen Wood, the Director of the Center for Law and the Environment in the Allard School of Law at the University of British Columbia in Vancouver. Welcome to our first no-fly zone event of the 2021-22 academic year with Australian lawyer David Barnden, who will be speaking about the Sharma case and a governmental duty of care to protect young people from the harms of climate change. A few introductory words. The No-Fly Zone speaker series brings legal thinkers and actors from around the world to speak virtually about pressing environmental law issues. It fosters national and global knowledge exchange without generating travel-related greenhouse gas emissions, which are amongst the largest source of greenhouse gas emissions for academics like us at the university. I, the center, and the law school are uninvited guests on the traditional, ancestral, and unceded territory of the Musqueam people. It's worth noting in connection with today's talk that Indigenous peoples steward much of the world's remaining biodiversity and experience some of the worst impacts of climatic change, and that Indigenous children and youth around the world are at the forefront of young people's movements for climate justice and also bearing the brunt of those growing impacts of climate change. Today's talk will be recorded, and the recording will be available on the center's website, which you can find by typing allard.ubc.ca/CLE. If you have questions, please use the Q&A function. You can type questions in the Q&A window at any time. You can see, at least I hope we've made the settings so that you can see questions as they are posed, and you can upvote the ones that you like. After David is done speaking, and he'll speak for 30 or 40 minutes, I will moderate the Q&A. As we are a relatively small group today, we're going to try to call upon people to unmute their mics and turn on their cameras to pose their questions live, and we'll see if we can make that work. So the Sharma case is an action brought against the federal Minister of Environment in Australia by Australian youth. And it concerns the proposed expansion of the Vickery coal mine and the resultant increase in GHG emissions. Earlier this year, the Federal Court of Australia made a groundbreaking decision in which it recognized that the Minister for the Environment owes a duty of care at common law not to cause personal injury to children and youth in making decisions about the expansion of the coal mine. And this is the first such legal finding of a common law duty of care in any common law country in relation to climate change, a duty of care on governments, that is. David represents 8 students, the students in the Sharma case, bringing the action. And David is the principal lawyer of Equity Generation Lawyers in Sydney. He's joining us from Sydney today in Australia. In addition to representing the plaintiffs in the Sharma case, he also represents Cata O'Donnell in a Federal Court of Australia claim about climate change risks to sovereign bonds. Prior to establishing Equity Generation Lawyers, he was a principal lawyer at the Environmental Justice Australia, where he represented Guy and Kim Abrahams in federal court proceedings against CBA, Australia's largest bank, for failing to disclose climate change risks to investors. He's experienced in litigating complex class actions. At Maurice Blackburn, he represented group members in proceedings against Guns, New Farm, Treasury Wine Estates, and Cash Converters International. He holds degrees in law and in applied science, coastal management. Thank you so much for joining us today, David.
Thank you, Stephen. Thank you so much for having me. It's an honor and a delight, and very grateful to be able to be involved with a Canadian audience and speak over Zoom. So look, I'm here in just firstly like to acknowledge the traditional owners of the land upon which I'm speaking, the Gayamagal people and their elders past, present and future. The land has never been ceded. So yes, today we'll speak briefly about the Sharma case. And, you know, it might be worth creating a bit of context as to how this case came about. And look, there's probably some similarities in the Australian context with respect to fossil fuels and emissions and even physical climate damages as there is to Canada. And that might be worth noting as we get into this. But it's probably also worth mentioning that we sit a little bit outside of the traditional environmental law frame, which over the last few decades in Australia has concentrated on judicial review and reviewing project by project decisions, which you may have a similar system in Canada, but we recognise the limitations of that, where even if there is a procedural irregularity or something missing from consideration, these decisions often get sent back to the decision makers and remade in the same way. And so we're trying to think about solutions to the climate crisis differently. As Stephen mentioned, we do have a case against Commonwealth government on non-disclosure of climate risks when issuing sovereign bonds. We've recently filed a case on behalf of 2 electric vehicle drivers to challenge a tax on electric vehicles in the High Court of Australia. And again, we're representing Guy and Kim Abraham's shareholders of the Commonwealth Bank, who are seeking an order under the corporations law to inspect the company books as a result of the bank, which is the largest bank in Australia, financing 7 new gas and oil projects when its public-facing policies said it wouldn't do such a thing unless those projects were in alignment with the goals of the Paris Agreement. So we're trying to move the frame a little bit of climate litigation in Australia. The Sharma case is a really good example of that, and we do represent eight students. They are all a part of the School Strike for Climate movement, an offshoot of which arose subsequent to Greta Thunberg's school striking actions and the Fridays for Future movement. In 2019, that culminated in 300,000 people hitting the streets of Australia to protest against government inaction on climate change. And here in Australia, we are notoriously bad on climate change. We are the world's biggest exporters of coal. We're the world's biggest exporters of gas. Our per capita domestic climate emissions are amongst the highest in the world. I think slightly lower than Canada. And we also suffer immensely from the physical impacts of climate change. Over 2019-20 summer in Australia, we experienced an unprecedented bushfire crisis on the East Coast, which is essentially the only part of Australia that isn't desert. And that culminated in damages to property estimated at 100 billion, which is pretty similar in Canadian currency. Up to 3 billion terrestrial animals which have died, 34 lives lost, around 3,000 homes lost. And so as we entered into the pandemic early last year, there's real frustration about what to do. So eventually 8 students, all aged between 13 and 17, instructed us to bring this case to the federal court to challenge the approval of this extension project in the state of New South Wales. It is an extension project, but the reality was that this extension aspect needed to be approved for this coal mine to go ahead. So it's it's a greenfield coal project. It's 100 million tonnes worth of Scope 3 emissions, and that's the sort of the factual basis that the court looked at. These 8 students were very keen and very happy to instruct us. That it does put them under a lot of stress and scrutiny in terms of being in the public eye, and we need constantly to be grateful for their instructions and for their bravery, but we are also honoured that we can actually help them to do something constructive. So there's a lot of tension there that our clients face, and it's worthwhile just pointing that out. The children can't bring federal court proceedings by themselves. In the federal court, probably as in Canada, children are under technical incapacity, so they need to bring legal action with a what used to be called a next friend, an adult, now a litigation representative. So enter 86-year-old Brigidine Nunn, Sister Bridget Arthur, who is representing the children, and she's very well renowned for her work with asylum seekers and younger people in Australia, representing them in court. The arguments were twofold, especially in terms of the remedies. We sought that, we asked the court to recognise a new or novel duty of care for the minister who were to make this decision on improving the coal mine, not to harm children when doing so. The second aspect was an injunction, excuse the Latin, a quia timit injunction, and that's an injunction which is appropriate when there's an apprehended breach of duty. So we're in this funny space where we need to, first of all, establish the duty, and then part of the remedy was to seek an injunction to prevent the minister from making a decision. I'll go into the duty aspect in a little bit, but with respect to the injunction, that wasn't granted. It's a higher legal threshold, so you need a reasonable apprehension of breach, and the judge said, look, I've been through this climate change evidence. I've looked at what the experts say. I've found that a duty of care has been owed, but I'm not convinced in the circumstances that the minister will actually approve the project. And so on that basis, the injunction wasn't granted. We consider this to losing a battle, but winning the war. But in the interim, around less than 2 weeks ago, the minister actually did approve this particular project to go ahead. So she has, despite the court finding that there was no reasonable apprehension of breach, this is in fact what happened in terms of her decision. And so we are currently thinking about what to do with that decision as a separate legal proceeding. But let's park that for the moment. The key aspect was establishing a duty of care. It's a pretty well-trodden path at least in Australia, in this common law jurisdiction, to look at certain salient features when establishing a new duty of care. There's 17 of them. They're not sort of limited, but they range from the idea of foreseeability of harm, the nature of harm, looking at the relationship between the person who ostensibly holds the duty and in this case the children, things like indeterminacy of liability. So that goes to whether or not you can actually tell who might suffer the harm. And another really important point, at least from the minister's perspective, was this idea of coherence. So we're in a situation where there's a statutory framework to approve the project. That's the the key federal environmental legislation in Australia, the Environment Protection and Biodiversity Conservation Act. People often view this act less as a protective act and more as a sort of an assessment rite of passage to tick boxes. And there's been reviews published recently on how our environmental laws are actually failing the environment in Australia. But there is no political will to change that at the moment. So in this situation, we had a federal act which is really the last step to the approval for this project to go ahead. So prior to that, there's been a process by which the state government looks at the environmental aspects of the project and then makes a recommendation to the minister. So by the time we got to court, that recommendation had already been made, and the minister needed to think about the issues under the Environment Act, which were mainly around threatened species. That's what the Environment Act mainly protects. But there is an ability and a requirement for the minister to think about social and economic issues. And so in that respect, we, in terms of the harm that we said the children would suffer, we said it was completely open to the minister to think about that in terms of a social issue. And as a result, this idea of incoherence with the statutory framework would fall away. And so that's, I'm not sure if I'm going into too much detail, but that's a key plank of the minister's argument. And that comes out quite strongly in her appeal submissions as well. And this case is one that is headed to the next appellate level before 3 judges, and the trial will be heard on the 18th, 19th and 20th of October. The expert evidence was critical in this case. Our key climate science expert, Professor Will Steffen, put on evidence which was uncontested and unchallenged, both from the point of view of opposing experts and a lack of cross-examination at trial. And so that expert evidence, to sum it up, said, in his view, the most likely best case scenario that the world faces in terms of average global temperature rise was limiting climate change to around 2 degrees if we pull out all the stops. So that in itself shocked a lot of our barrister team. They were like, what? Really? Are you serious? I'm not sure if it shocked the court, but it was uncontested evidence. It sits there in the judgment. From more or less a 2 degree world, Professor Steffen said, you start to look at tipping points, and there's a range of tipping points, involving melting of polar ice caps or ice caps in Greenland, the sort of the currents in the Atlantic, bushfires with feedback loops to create more carbon emissions. And those feedback loops were more and more likely as global temperature rise will exceed 2 degrees and on the way to a 3 degree threshold. His evidence was that if global temperature rise would get to around 3 degrees, it probably wouldn't be stabilized there because of the tipping points. And so we would head into a hothouse Earth scenario, which is 4 degrees of temperature rise or more. And that equates as significant harm. I mean, it's almost unimaginable. I mean, Canada recently experienced the heat dome. We've spoken a little bit about the bushfire crisis in Australia, and that's where we're currently at on little over 1.1 degrees average global warming. So we're in a position where the submissions from the minister, who was very keen to retain the ability to approve this project unencumbered, was that the 100 million tonnes of carbon emissions would equate to 1/18,000th of a degree in temperature rise. And so it was characterised as tiny, but the judge characterised it as tiny but measurable. And in accordance with the precedents in Australia, if the risk of harm were to be increased, then that is sufficient to satisfy one of the arms of the salient features to create a new duty. So the judge characterised this as being a real risk of increase in harm to the children. The children are, in the eyes of the law and the expert evidence, vulnerable. They can't vote in elections. They only have one earth to live on. They will suffer the worst impacts of climate change. And the case was brought as a class action on behalf of all children under the age of 18 in Australia. The court found that this relationship between the minister and the children, again, was sufficient to satisfy this salient feature of vulnerability. And in part, the court did look at some doctrines around the requirement or responsibility of the state to look after children, especially vulnerable children. So this parens patriae, and again, excuse the Latin doctrine that exists in sort of other aspects of law in Australia. So we sort of see a combination of this vulnerability of children who will suffer the worst impacts of climate change, and tension between this idea of, a very, very tiny, paper cut worth of responsibility in terms of temperature rise, but that was translated with the evidence by Professor Stephan to say, well, look, every little bit counts, and if you increase the risk, as you go over 2 degrees, it's potentially catastrophic. And that accords really, really well with the case law in Australia, or that we can rely on, with respect to, there's cases around dust and silica, and the contribution of certain grains of silica that people may inhale and cause lung diseases. So that sort of responsibility is sort of known about in law, and there's jurisprudence on it. At the end of the day, I'm just kind of wary of time here. At the end of the day, the judge did work through all of these. Well, he worked through key salient features. He didn't work through all 17 of them, but sort of touched on the key points. He found that a duty of care did exist to avoid harm in this decision-making process on the particular mine. There's a phrase in the judgment which, well, for the first time I read out loud, choked me up quite a lot, but it is worth repeating. It's paragraph 93, it's 293. It says, "It is difficult to characterise in a single phrase the devastation that the plausible evidence presented in this proceeding forecasts for the children. As Australian adults know their country, Australia will be lost, and the world as we know it gone as well. The physical environment will be harsher, far more extreme, and devastatingly brutal when angry. As for the human experience, quality of life, opportunities to partake in nature's treasures, the capacity to grow and prosper, all will be greatly diminished. Lives will be cut short. Trauma will be far more common, and good health harder to hold and maintain. None of this will be the fault of nature itself. It will largely be inflicted by the inaction of this generation of adults in what might fairly be described as the greatest intergenerational injustice ever inflicted by one generation of humans upon the next. And so it's extraordinarily emphatic, this judgment. And it's important to understand that the duty of care, the scope of that duty is reasonably restricted. It's a duty to avoid personal injury and death. It's not a duty to avoid economic harm. That might arise from property damage or bushfires, or impacts to investments, people's superannuation, things like that. The judge sort of relied, to arrive at those findings. The judge looks particularly at bushfire smoke, saying that, look, it's reasonably foreseeable that anyone in Australia could be exposed to bushfire smoke, and there's some quite horrifying statistics around and modelling with respect to the number of today's children who will be impacted by bushfire smoke and potentially need to go to hospital. The second aspect was around heat stress, and again some pretty horrifying statistics. I think one of them was up to 1 million of today's children will suffer some heat stress episode that might require being admitted to hospital. And so we also did put on evidence around economic loss, and there was some really interesting modelling that was state of the art, and it said, look, in today's amount, children could be sort of expected to lose between $175,000 and $250,000 in terms of just personal wealth, due to decreases in property values or investments, things like that. That was sort of not taken into account for the purposes of this judgment, of this narrow scope. But it's the evidence is really quite frightening that didn't in fact go into the creation of this duty. Equally, the evidence around tropical diseases extending further south, well, at least in the southern hemisphere, as the weather gets warmer. So we put on evidence by not just Professor Steffen, but also 3 others. We had an actuary, we had a general economic expert who came up with those figures, as well as a public health expert. So we kind of painted the picture to the court of quite broad scale damage. And we also had not just the children themselves, but senior firefighters put on evidence. And so this is lay evidence, not expert evidence, just to give a flavour to the court on what is extreme now will be the normal or potentially the less extreme in the future. And so in Australia, perhaps it's similar in Canada, I'm not sure, with respect to wildfires. I think in one state around 10 years ago, the firefighting sort of code or regulations changed to the extent that no one is now advised to stay in or near their homes to protect it, simply because you previously could, with the idea that the fire would sort of pass over and you could protect yourself in a bath or a basement or something and come out. Now the fires are so hot and of such an intensity that the only reasonable response is to evacuate. And so firefighting kind of takes on a different role now. It's more a sort of just get people out, because in many instances you just can't protect. And you see in this a real sort of physical, visceral way that climate change is altering our kind of our ecology and the threats that people have to face. So there was a lot of evidence. We had a 4-day trial, and now we're in a world, as I said, where the minister has appealed. We have a 3-day trial before 3 judges of the federal court. In Australia, that's an intermediate level of appeal, and the next level goes to the High Court of Australia before 7 judges. And whether or not the case will go there is to be seen. But we are in a world where we are putting on. Well, we've just put on submissions yesterday for that appeal, and the court has, given the public interest nature of the case, have made our submissions and the minister's submissions available to the public. Probably just one last thing to say before I finish up is that in the minister's decision to approve the project, which is a different inquiry to what's happening now at the appeal level, which is the existence of the duty. So when we talk about the minister's decision to approve the project, we start to think about breach. In her decisions on this coal mine and one previously, she is invoking the substitution argument, which is to say, look, I've thought about harm to children. If that duty does exist, and duty which I'm challenging, it's fine, because in her view, even if the mine did not go ahead, the demand profile for coal will cause the same amount of coal to be burnt on a global scale. And so this is in the context where Australia, I think, is responsible for having over 70 of the proposed new and extended coal mines in the world, when there's a total of 150. So around half. So it's quite the phenomenal type of argument when she's coming to approve these projects despite an existing duty. So that's sort of the landscape where we're at the moment. Hopefully that was a potted journey through a reasonably complex issue, both in the courts and also with respect to the political background here in Australia. But there is a 160-page judgment, and no doubt more judicial commentary to come. So I'll leave it there. Thank you.
Thank you so very much, David. That was a really helpful and clear sort of summary and introduction to this case. I find myself simultaneously exultant and aghast, really exultant at this very significant legal victory in having the declaration that the government owes a duty of care to the children of the nation in relation to climate change. And that is really a major step forward in climate justice litigation. But at the same time, aghast at the evidentiary foundation on which that duty was found, especially the projections of likely futures that are the grounding. I would like to ask you a question to get things rolling, and then I will see what's coming up in the Q&A. And it relates to that, the sort of the future world that Justice Bromberg saw as a result of Professor Stephan's evidence. So this idea of a growing risk cascade or an exponentially increasing risk of catastrophic harm was really crucial to the reasoning in the case. And to me, it was what enabled the court to find, or it was what enabled the court to refute this de minimis argument, or this "it's so tiny it doesn't matter" argument that the government put forward. I wonder if you could just reflect on the significance of that reasoning for climate change litigation.
Yeah, look, it's a really important point, and as we, one of the main challenges for climate change litigation is the extent and complexity of the problem when there's so many contributors. So this is a really important way to sort of articulate the problem, and it's a way that does correlate with the law, and it does exceed this idea of what is de minimis. I mean, there are sort of judgments that talk about drops of water in a flood being de minimis, but on the other hand, there are judgments that talk about grains of sand, contributing to pulmonary issues which aren't de minimis. The court looks at this idea of a real risk of harm, and amongst these salient features, that is really critical, and it looks at the magnitude of harm as well. And so to be able to step through those problems of a 100 million ton mine being de minimis when we're talking around gigatons in a carbon budget, it's really important, and it's important to know that this is, I mean, it's a sensible judgment. It is really strictly based on the development of the law. The minister's submissions to the appeal, which are now public, emphasize or put forward strongly the idea that this decision that the minister makes is a political decision and is non-justiciable by the courts. But that's not our view, based on this very careful reasoning to get us to this point. I might just want to add one other thing, that the idea of changing social attitudes was also important in the judgment, and we can sort of that picks up the idea of vulnerability, and it also sort of takes into account the expectations that the community has on a minister in her role. So I think that is also helpful to as an overlay to break through the problems of being de minimis.
Look at me forgetting to unmute myself. Thanks for that, David. I'm sure there will be follow-up questions about this idea that this is a decision that is too political or policy-laden to be justiciable. But I'd like to go to the Q&A queue. And there's a question from Austin Earhart, and we're going to see if we can enable Austin to pose that himself.
Can you hear me?
Yes, we hear
I'm
you.
popping up. Perfect. Great. Thanks. Thank you very much for that. So my question is, going into the hearing, how confident were you about the strength of your case? Could be a scale of 1 to 10, or you can go into more detail. And as a follow-up to that, were there any particular arguments you thought were very strong? And did any unexpected challenges arise over the course of the hearing or the process more generally?
Yeah, sure. Look, I mean, it's a good question, one we get quite commonly, but most lawyers will generally avoid talking about prospects of cases with respect to concern around disclosing legal advice and obliterating privilege. But I mean, the context is that in Australia we have solicitors and barristers, or lawyers and barristers. Barristers are specialist court advocates. Solicitors like me, do a lot of the background, do the liaising with clients. We probably have one of the best imaginable barristers, Hutley, who's a senior counsel, arguably recognised as the best commercial advocate in Australia, and has been famous or infamous for publishing public opinions on climate change and directors' duties. So we are very confident in our team. With respect to issues that have arisen, I mean, the notice of appeal sets out the grounds of appeal, and so not only do we have quite a focus on like the decision of the minister being a political decision, which we strongly refute, because the key function of the judiciary is to put limits on decisions by the executives that might harm people, that might harm the vulnerable. This is like, it's not controversial, and to paint a decision to approve a coal mine as a political decision is, it's quite confounding in a way. So that's something which there'll be quite a focus on at the trial. There's also challenges to the findings of fact by the judge, and so in a world where there was uncontested evidence put on, the minister is challenging the judge's interpretation of that evidence. That translation of what the evidence looks like in the form of the expert report to what it looks like on the page of the judgment, and that's quite interesting in the context of having no other evidence put on by the minister. So look, there's it is a battleground. We are in a common law jurisdiction where there are 17 salient features that can be looked at to establish a duty, and this is a novel duty. And so yeah, look, the battle lines are pretty well drawn.
Thank you very much.
Yes, thank you, David and Austin, for that. I'll circle you back to this political issue. Yeah, I just, I wonder, well, I'm not sure how if you're in a position to comment on the sort of the implications of the decision outside of Australia, but in Canada, the courts still do cling to this policy versus operational decision distinction, and it may well be it would be a very significant hurdle for a decision like that here in Canada. But I just wonder how, if the submissions on appeal are public at this point, how is the minister framing this argument, and what do you think the Australian law says about it? And now you have to unmute.
There we go. Thank you. And the other day I unmuted specifically to sneeze and then just muted again. So I'll at least didn't do that. But now I've told you about it. So yeah, the submissions are public. So it's a strange argument in a way that the minister refers to the Paris Agreement as a way to manage the global issue of greenhouse gases and limiting the the global rise in temperature. And so it's interesting and kind of disheartening in a way that the Paris Agreement is being used as a shield by the minister to say, look, there is this global agreement in place to limit greenhouse gas emissions, and that is the political dimension. She's arguing that we are attempting to make policy decisions around greenhouse gas emissions, which goes far, far beyond the case at issue, which is a case around one coal mine, and it's around the harm of that coal mine to children. The Paris Agreement was the only evidence that the minister put on in trial. And what is also interesting is that this mine is largely going to produce thermal coal as opposed to metallurgical coal, for which there's a different demand profile for energy, and that coal will largely be burnt in Taiwan, Japan, and South Korea. And you know, if the minister continues to invoke the Paris Agreement, that of course is limited to domestic emissions, you know, under the accounting rules of the Paris Agreement. So in essence, they're trying to restrict or characterize this as a political judgment for which a political a decision which infringes on policy and political decisions when it's truly about harm. And I find it pretty interesting, and we're in you know, the political situation in Australia is that due to our high amount of exports of coal and gas, that we're not technically responsible for those emissions, yet we're profiting from them. So it's an interesting and kind of a sad argument at the same time from an emotional perspective. I'm not sure if I've answered your question, but there's some context around it.
No, that was very, very useful and telling context. I'm going to go to the next question in the queue, and it's from Winona Klempt. And we will see if we can enable Winona to pose that question, if you'd like. You don't have to.
Sure. Yeah, so I was just wondering, in our Indigenous Studies course, we've been talking a lot about how Indigenous legal orders talk about their mutual reciprocal duty of care of the land, and you talk with a bunch of experts for your arguments, and I was wondering if there were any Indigenous laws consulted during this judgment as well.
Yeah, great question. It's pretty like down the line judgment, which focuses on duty of care for sort of authorities and people in power. And so any kind of reciprocal duty that Indigenous people in Australia might have with respect to care of land just isn't a sort of a technical judicial consideration. So you know, the types of things that were looked at, especially with respect to the case law, were things like councils making decisions to approve developments when they knew those developments were on contaminated land. And so it's a very kind of top-down legal analysis. The one thing also worth noting, and you know, I don't have really much to sort of play with respect of your question, but the one thing, a legal issue which is prevalent in Australian law is this idea around discretion, and the minister in this case does not have discretion to make a decision. She has discretion to say yes or no to the project, but she must make a decision, and so that's quite important in the context of recognizing a duty on a non-discretionary decision. But thank you, it's a really good question.
Thank you.
Thank you, Winona. David, I would like to now turn to this argument that appears to be central, that you mentioned was central to the minister's decision to approve the mine, which is the substitution argument. I've seen it referred to as the drug dealer defense. If we don't sell it to them, someone else will, because the demand for it is just there and we have no control over the demand. How was that received? If you're able to share with us, what was your reaction to that reasoning?
So look, as a lawyer and with my obligations to the students and Bridget, we keep quite dispassionate about these things. But from a question of logic, it just doesn't make sense, right? Like you should be responsible for the decisions you make and the harm that arises from those decisions. You shouldn't look to what other people are doing. And you know, we see, yeah, I mean, it is a fallacious argument, and it is one that courts have grappled with in Australia before and have, in some circumstances, accepted. So it is a dangerous argument, but it does show a complete disregard for any connection between the action to approve a mine or the emissions from a coal mine and the harm. So the response to that by our clients and the public in general has been of kind of outrage and shame as well.
Yeah, I sort of think, can you imagine if a child were hit crossing a busy highway, the driver of the car that hit them would say, well, if I hadn't hit them, someone else would have. Also, I don't know if you noticed this, but I think that Royal Dutch Shell raised the same defense in the recent Royal Dutch Shell decision out of the Netherlands, where the Hague District Court found them to owe a duty and be liable to the citizens of the Netherlands in relation to their greenhouse gas emissions from their global operations. And the court gave very little room for that sort of argument. Yeah. Now, is there another? Okay, so I'm going to keep going then, if you don't mind. And I think the next question that maybe I'll sort of head back toward just questions of sort of professional role and practice, similar to what Austin raised earlier. And that is, what are the sort of challenges and rewards of representing children in terms of both having children as clients, but also distinguishing children from adults for the purpose of, for the legal purposes in terms of them constituting a distinctive class?
Yeah, look, really, really good question. From first principles, the children are our clients, as is Sister Bridget, who represents them. To receive instructions, we need to be assured that the children have capacity to give us instructions, and they certainly do. And in terms of, I think, just speaking generally, the media in Australia, who can be quite critical of children actually doing something and having an impact, they like to paint them as being a proxy for someone. And what we see in the climate strike movement is that this is certainly not the case. I mean, there's no question around the agency that that the children have and their capacity, and I think, I mean, anyone who deals with younger people in this space will pretty quickly realize that it's them who are educating their parents, and to a certain extent us. You know, we've learned a lot from working with the children, just around expectations of you know, what to do and say in meetings, and it's been great. And there should be much more of this, like working together. And so it's been really good for me, who've sort of been in this area for what feels like a long time on and off, that, you know, there's so much energy and so much hope and so much passion. And so from a very selfish point of view, it's great. But also from the point of view of being able to help, it's obviously very good. But you do need to be aware of the stress and strain that it places on younger people. And there's a common complaint, well, not necessarily complaint, but acknowledgement that it's not fair. It's not fair that younger people need to do this. And it's not fair that it takes up so much of their childhood when they could be otherwise exploring other things about life. So yeah, it's a pretty interesting dynamic.
Yeah, I can only imagine. And we've seen some of the pressures and some of the hostility that many of these children are faced with. So I really do appreciate your pointing out the real pressures that they bear when they step forward to do things like this. Changing gears again a little bit, I wonder if you can reflect on the implications of this judgment for the possible legal liability of private parties, duty of care on non-governmental actors. Can you say anything about that?
Look, I'd probably refer to third-party commentary that in Australia have suggested that this judgment sort of opens the door to that type of liability and those types of duties being recognised. And again, if it were, you would go through the same salient features. You know, look at the vulnerability of the children, their relationship to those who are making decisions, and the impacts of climate change. So it's certainly a step in the right direction in Australia, and it's encouraging that we can do this from a tort law foundation and do it sensibly, in lieu of having some of the human rights frameworks that exist in Europe.
Yeah, absolutely. I'll just ask you one final point, and it's just a point of information. Can you tell us where people can find the written submissions for the appeal? And maybe Kira could sort of type that in the chat for everybody to see if you happen to know. If not the website address, at least where one would search.
Okay, hang on, I might be able to copy and paste it here. Does that come up in the chat?
That actually came to panelists, so maybe Kira, you could copy that in for everybody.
I've done. Okay.
Oh, there, it's done. Okay, so fedcourt.gov.au. and then a range of stuff after that. Well, that's really helpful. And I'll just repeat the dates you told us. 18, 19, and 20 October will be the hearing. Do you know whether that will be broadcast publicly?
It will be online. I'm not sure if there will be a live stream of it, but we will. We will make those inquiries of the court, and we can tell you whether there's a live stream. There's a process by which you can approach the court registry to get the details to participate in well, not to participate, but to tune in.
Yeah, exactly. Well, thank you so much. This has been really, really, really informative and inspiring, I must say. In addition to thanking you, David, for giving generously of your time to share your experiences and knowledge with us, I just want to alert people that the next of our events in the No-Fly Zone speaker series will take place on October 7th, and that's a Thursday. It will be 9:30 a.m. Pacific time, when we're going to be hearing from a lawyer in another climate change case, this time Rhoda Verheyen of Günther Partners in Hamburg, who was one of the lawyers representing plaintiffs who successfully challenged the German federal climate law as being a violation of German people's human rights. So going from the sort of civil duty of care realm to the human rights realm. So please tune in for that. And with that, I will just once again thank David and wish you all success in the appeal of the matter. And if it goes all the way up to the High Court, success at that level as well. So thank you very much.
Thank you very much for having me and all the very clever questions. It's been a delight.
All right, thank you, everyone. We will adjourn.